Hello and welcome back to the podcast, brought to you by Yee's Law Journal. In today's episode, we're diving into the latest and much talked about antitrust guidelines on standard essential patents, released on November 8, 2024, by the State Administration for Market Regulation, or SAMR. This is China's first dedicated guidance focused on antitrust compliance specifically for standard essential patents, or SEPs, and it marks a big step forward in China's role in SEP governance on a global scale.
That's right, Josh. Let's grab a coffee, get comfortable, and break down this new guideline. It's quite a big deal. The document provides a clear framework for SEP holders, clarifying the boundaries of what is and isn't acceptable in SEP licensing. And it aims to make sure that innovation can flourish without unfair monopolistic practices getting in the way. To start, I think it's key to go over what exactly a standard essential patent WEA is, as it's the foundation for understanding the guidelines.
Absolutely. So let's get to it. In a nutshell, a standard essential patent is a patent necessary for implementing a specific industry standard. Without it, a company couldn't make compatible products or services that meet certain industry requirements, like those in 5G or the Internet of Things, IoT. Think of it as the building block of compatibility across global markets. However, SEPs also have a built-in monopolistic quality. SEP holders control the essential tech, and they can wield a lot of influence in licensing negotiations, impacting both pricing and market access.
Right, and that's where the potential issues come in, right? SEPs, while essential to maintaining global standards, also come with the risk of abuse. SEP holders might use that essential status to block competitors or inflate fees. This is why SAMR's guidelines are so important. They're setting boundaries to avoid exactly that type of behavior.
Exactly. Now let's connect these guidelines with the larger legal framework. In China, the anti-monopoly law is the main law governing market competition. It identifies and penalizes various types of monopolistic conduct. But here's the thing. Because SEPs involve both competition and intellectual property, applying the usual antitrust rules can get complicated. So, China's Anti-Monopoly Committee issued the Antitrust Guidelines for the field of intellectual property to give more specific guidance, especially around key principles like FRAND, that's fair, reasonable, and non-discriminatory licensing terms.
Right. And that's where these new SEP guidelines come in. They take it a step further, focusing directly on SEPs, defining how SEP holders should act, how they should license their patents, and even how to balance innovation rewards with the need for open market access. It's all about protecting both SEP holders and companies that need those SEPs to be competitive.
Well said, Alice. And that brings us to one of the highlights of the guidelines. Preemptive and preventative supervision. The guidelines give SAMR more power to step in before a problem becomes a major issue. SAMR can issue early warnings and request written reports if it detects potential monopolistic risks. In 2024, for instance, SAMR used this very approach with a certain patent pool in the automotive wireless communications space. They stepped in early, flagged potential risks, and it really helped reduce antitrust issues before they got out of hand.
Yes, that early intervention is a huge step forward. Another area the guidelines really dive into is disclosure, FRAND commitments, and good faith negotiations. These fall under what the guidelines call good practices, which means they're not technically mandatory, but they carry a lot of weight in antitrust investigations. The guidelines encourage SEP holders to disclose essential patent information early during the standard setting phase. This transparency helps avoid what's known as patent ambush, where a company hides its patents and only reveals them later to demand high fees, like what happened in the Rambus case with the EU.
Oh, the Rambus case. Classic example. Rambus held off on disclosing its patents during the standard setting process, then later required companies to pay high royalties to use those standards. The EU flagged that as a patent ambush and ordered Rambus to make concessions. In these new guidelines, SAMR goes even further by making it clear that FRAND principles apply even after a patent transfer. This prevents SEP holders from transferring their patent rights to sidestep those commitments.
And that brings us to good faith negotiations. The guidelines require SEP holders to make clear licensing offers, including detailed terms, and give reasonable time for the implementers to respond. This is SAMA's way of ensuring that everyone comes to the table ready to negotiate fairly.
So Alice, now we're moving into the third big area of the guidelines: detailed standards for abuse of market dominance. The guidelines are incredibly specific here, listing types of abuse like unfair high prices, refusal to license, bundling, and adding unreasonable licensing terms. For example, on pricing, the guidelines say SEP holders should consider the number and value of patents and any changes in the market. This way they can avoid unfairly high licensing fees that might hurt competition.
And on refusal to license. The guidelines make it clear that SEP holders can't refuse a license if they haven't made a genuine effort to negotiate. This could impact licensing strategies, especially in sectors like IoT and automotive, where SEP holders sometimes want to license only to final product manufacturers, not component makers.
Absolutely. And SAMR even provides guidance on bundling. While bundling SEPs can be efficient, the guidelines warn SEP holders to ensure that bundling aligns with industry norms and is technically necessary. This way, companies can avoid forcing implementers to license extra unrelated patents.
Right, and that brings us to the last big focus area, collusion and patent pools. SAMR is sending a clear message here. When SEP holders are involved in standards development, they can't collude to block other participants or alternative technical solutions. And patent pools, which can be good for efficiency, need to be careful not to create monopolistic agreements. They shouldn't be sharing sensitive info like pricing or production data.
All of these measures set some serious expectations for SEP holders and provide much clearer guidance for companies involved in SEP licensing. For SEP holders, the guidelines offer a roadmap to avoid risky practices like patent ambush or refusing to negotiate. For companies that need SEP licenses, understanding these guidelines can give them leverage to challenge unreasonable demands or defend themselves in negotiations.
Well, that wraps it up for today. China's new SEP guidelines are a big move toward transparent, fair SEP licensing, and they add clarity to an area that can be confusing for companies worldwide. Thanks for tuning in today, everyone. And if you found this helpful or have questions, feel free to leave us a comment or reach out.
And if you haven't already, don't forget to subscribe to Zai Kuai's Law Journal. Share this episode with anyone who might find it useful, and follow our updates. We'll keep bringing you fresh insights from the world of law. Thanks again, and we'll catch you next time.